Right away, notice the tone. This isn't just another routine hearing. When someone already serving time walks back into court facing new felony charges, every decision suddenly carries double the consequences. The real question is, does he realize how high the stakes actually are?
Good morning. Are you Victor Charles Campbell Jr.?
Yeah.
And Mr. Parker, will your client waive the formal reading of the indictment in each case?
We are.
And it looks like we are going in 21-36426 and 22-39050, correct?
There's also a dismissal in 305.
All right, Mr. Campbell. In cause number 21-36426, you're charged with a third-degree felony offense of evading arrest or detention with the use of a vehicle, and that's from November 28th of 2020. The indictment further...
This is where criminal law gets brutally technical. Prior convictions don't just sit in the background. They act like multipliers. Think of it like leveling up in reverse. Every past conviction increases the legal risk, turning what might have been a manageable sentence into life-altering exposure.
Alleges that you were previously convicted of assault family violence, a third-degree felony, December 5th of 2014. And how do you plead to that charge?
Okay.
So to the charge, let's start with just evading arrest or detention with the use of a vehicle from November 28th of 2020. How do you plead to that charge? Guilty or not guilty? It's guilty or not guilty. Either you did it or you didn't do it.
I thought that's what the plea was.
There's a plea agreement means in my court, you either enter a plea of guilty or not guilty.
Well,
Mr. Campbell, I understand that you're already doing time for a murder and that you don't really care about what's going on today.
I'm saying I'm pleading no content because he never even went over the indictment with me.
I find that hard to believe. So here's the
To
thing.
actually be honest, I just only been here for like about 30 days. So I got like 3 weeks or 30 days and about 2 weeks of being here.
He was pitching over here.
Here's something many viewers don't realize. Defendants don't always control how they plead. Judges have authority over courtroom procedure, and when a plea deal is involved, they can reject certain plea types entirely. So what we're watching isn't stubbornness alone. It's a power struggle over who controls the process.
So, the nature of the crime, no cause number, and the magistrate, as far as the indictment, I never received one. And due to the fact of the nature of the charge of being from 2018, you have 5 years or 4 years to indict me to actually send that indictment.
Sir, the
That's
allegation,
why I'm pleading no contest.
I'm not going to
I'm
allow.
not guilty. It's fine.
Here's the thing. I don't have to accept any plea agreement.
It's fine.
Okay? So
Pause right here. This is the fork in the road. One decision could mean certainty with 18 years. The other risks 25 to life. From a legal strategy standpoint, certainty often beats gambling in court. But psychologically, some defendants struggle accepting guilt even when the math says they should.
you can, in that evading arrest or detention case, if you go to trial and you're found guilty, it's habitual. You're looking at 25 to life. We can set it for trial. I'm not playing games and I'm not going to accept the disrespect. If you want me to follow this agreement and go along with the plea agreement.
Notice how frustration is escalating on both sides. Judges are trained to maintain control of proceedings, and repeated resistance can actually hurt a defendant's credibility. Courtrooms run on structure. Once communication breaks down, outcomes often become less favorable for the person on trial.
And you can go on, do your time and be done with it, then we can get that done. But you're not going to show disrespect while we're doing it to me. Do you understand?
Yes.
So if you want to go forward, we'll go forward. If not, we'll set it for trial. Mr. Smith will get ready very quickly and we'll get your case tried within a month. And it'll be habitual 25 to life. What do you want to do?
It's 18 years.
No, the plea agreement.
If you go to trial, listen to me. If
Yep.
you go to trial and you're found guilty and your prior convictions, stop talking over me. If you go to trial and you're found guilty and those prior felony convictions are true, then you're looking at habitual 25 to life. Today, there's an agreement for something different. I'm glad to accept that if that's what you want to do. But you're going to either accept responsibility and plead guilty or plead not guilty.
Yeah.
That's your choices. So let's go back then and cause number 21-36426. You're charged with a third-degree felony offense of evading arrest or detention with the use of a vehicle from November 28th of 2020. How do you plead to that charge? Guilty or not guilty?
That's what I'm saying. You saying assault family violence. The evading arrest is
Listen.
guilty.
It's evading arrest or detention with
But what
the
are you
use.
looking at? I'm saying
I'm looking at your indictment.
He's saying you got indicted for
I got that.
evading. In 2014, you were
Hold on,
convicted of something.
Mr.
Okay.
You've probably already tried. Let me take care of it this way.
I-
Place that in front of your client, please. Now, that is cause number 21-36426. That indictment alleges in paragraph 1 that you committed the third-degree felony offense of evading arrest or detention with the use of a vehicle from November 28th of 2020.
Yeah.
How do you plead to that charge?
I just pleaded no contest. She didn't want to substitute contest.
How do you plead to that charge? Guilty or not guilty? We're not going backwards, okay? I already told you you're not going to plead no contest.
Guilty or not? You plead guilty or not guilty?
So if I'm telling you no contest, what is that?
It's nothing, and it's nothing. You're not allowed. I can take a plea of no contest, or I cannot take a plea of no contest. That is up to the court. You're not legally entitled to plead no contest if there's a plea bargain. I'm telling you, if you want me to accept the plea agreement, you're going to plead guilty or not guilty. I've already told you that. I'm not going to tell you again. If I have to tell you again, guilty or not guilty.
I'm saying.
Period. I'm about to set your case for trial.
That I'm not. That's basically saying that I'm.
We're not going to argue the law.
I'm not, or I'm guilty.
We're not arguing
It's
the law.
basically just saying that I can state that.
I'm not going to argue the law with
I'm
you.
guilty. Just sign. Go ahead.
I don't-
That's guilty. Go ahead. That's what y'all want to do. That's
Listen.
fine. I'm cool, man. Just go ahead. And
Well,
give
you're
me-
not. You're really not being cool, and you're making me very frustrated.
Ma'am, I respect your call. Just go ahead and give me the
Nothing here.
Plead guilty. There
Okay.
you go.
So you plead guilty to evading arrest or detention
Yeah,
with
no.
the use of a vehicle. Okay. The next count, the next paragraph that you're looking at says that you were previously convicted of assault family violence December 5th of 2014. Is that true or not true that you have that conviction
That's
on your
true.
record? Okay.
And that's not the same
That's
case
okay.
as far as
Look.
evading arrest, man. That's two different charges. So if you really want to be technical as far as being a habitual, that's called a repeated offender. But
Exactly. And listen, so Mr. Campbell,
that's
that's,
15.
wow.
I think.
Do you want to come sit up here and be the judge? You're so smart.
I don't know. If you need some help, man, I wouldn't mind.
I feel like I might because I'm not understanding. Mr. Campbell, you're getting a deal to go on count one only, which makes you a repeat. I get that you've been through this before and you understand what's going on, but you're making this more difficult. If you go to trial, you could be habitual. Today, if we take this great plea agreement, it's repeat. I understand that. I've been doing this for 30 years. Okay? So, did you enter your plea of guilty freely and voluntarily?
Guilty.
Did anybody force you to plead guilty today?
No.
Okay. So I have let's go to the next case then. In cause number, and here's that indictment. In cause number 22-39050, you're charged with and in this case, we're just going on count one.
Count one only.
So in this case, we're going on count one only. So it's just the offense of tampering with physical evidence, a second-degree felony from November 28th of 2020. And how do you plead to that charge? Guilty or not guilty?
I pleaded no content, but guilty now.
So are you pleading guilty to this charge?
Yeah.
Okay. And did anybody force you to plead guilty in cause number 22-39050?
We just answered it.
I know I have to ask you in each case. It's required by law. It's required by law that I ask you that in every case.
Just pleaded guilty.
Okay. And nobody forced you to do that, right? Speak up so the record can take it
No,
down.
I think you did. You did, but let's go. So no.
Okay. So I have in both of those cases here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed those, did you go over them with Mr. Parker? The documents on the tablet, y'all have that? And do you understand if I follow the agreements that you've made with the district attorney that you'll be waiving or giving any right to appeal? Yes or no, please? Do you understand that?
What we signed the documents.
Okay. You have to answer out loud, yes or no, so that the record's clear that you understand, that I know you understand what you signed, okay? I'm not trying to, doesn't have to be that difficult. Just get in, get your deal, and get out. You're making this way more difficult than it has to be. State tender's number 1 in each case. It's admitted in each case. Is there any evidence that Mr. Campbell is not competent?
No, you're good.
You said
I just printed the wrong thing.
She asked me about if there's any you weren't. I said, no, there's not. He's confident.
All right, Mr. Campbell, I'm going to find in each of your cases that you, Mr. Campbell, Mr. Campbell, pay attention to me for a second, please.
Oh, hell, please. I ain't drinking.
Mr. Campbell, you ready?
Yeah.
In cause number 2136426, I'm going to find that you entered your plea of guilty and true freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, and at this time, find you guilty of evading arrest or detention with the use of a vehicle. Find that prior conviction true. Sentence you in accordance with your agreement to a term of 18 years in the Institutional Division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive.
So can you say that on record?
I'm on the
Yes.
record.
No, I'm saying say that how long I've been in custody.
I don't know. I don't have that information.
5 years.
Okay, you'll get all the credit that you are entitled to get.
How long?
And cause number 2239050, also find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty, and at this time find you guilty of tampering.
And this is the moment everything settles. After all the tension, the system returns to procedure, confirming the plea is voluntary. Legally, this step protects the conviction from appeal later. Emotionally, though, you can feel the exhaustion in the room, a long battle ending not with drama, but paperwork.